Mention. Item number 1.
I'm praying for some time.
Yes, Mr. Gupta.
Yes.
3 weeks time.
Yes.
Please allowed for affidavits. Yes, accordingly on so. Next matter same.
Yes, ma'am.
Yes, ma'am.
Number 3, you say there is no substantial questions of law.
In my ombudsman, there's
no.
There's nothing.
So, Mr. Dasgupta,
Yes, sir.
what to do then?
I have placed, I have given the substantial question of law, recasted substantial question
So
of
you
law.
convince the court. Can this failure of the tribunal, the appellate tribunal, which is the final fact finding authority, to consider material evidence be a substantial question of law?
Because they have not considered the material evidences and factual and legal issues. So it's a perversity order. And when there is a perversity order, then it raises the substantial question of law.
Where is that judgment? Let's see the authority that you're relying upon.
Yes, perversity tribunal order raises substantial question of law.
Which judgment
The
is that?
tribunal sister acting as a final fact-finding
No,
authority.
where's the judgment? Your submission is well.
Yes, yes.
Yes. Substantial question of law sometimes can be mixture of law and fact also. But in this case, you're supposed to raise the substantial question of law, which the court will frame if we find that substantial question of law are involved.
The Supreme Court has held that when the order is perverse, based on no evidence, a complete misleading of evidence, or arbitrary disregard to the material facts, it raises substantial question of law. In the case of Goya Din versus Haryana, Prasad 2001, 1 SCC 501. Then Supreme Court order.
You're reading
of
from
law.
commentary or
Yes.
something? We're reading from?
Just from a note. Reference I have given.
Then you will give us the courtesy of
Improved
carrying
order,
that note or
order
judgment.
distorts and
So where's the
misrepresents.
judgment?
Yes, my lord, I will.
Have you come prepared a judgment today?
Next
See,
day.
it's not mechanical, just that you put a questions of law that the court accept them. Now the objection has been raised by the respondents that there's no substantial questions of law to be said anymore. And so if we're having preliminary hearing only on the framing of the questions, substantial questions, if there's no substantial, then the matter goes.
No, my lord.
Kindly, if you say that your main ground is that number 1, is that final fact finding authority is
Has not considered the material evidence on record.
and number 2 is that they have not even looked at your grounds of appeal.
Yes, they have not looked at it. This is a mistake.
You kindly come prepared. You also.
Well, otherwise, if we take lordship through the impugned order, my lord, every aspect has been discussed.
That is what. Let him show that there is some question of law has arisen.
The entire case is that they produce some invoices, my lord.
No, okay. I will produce
Yes,
my
sir.
laws. Just-
You put in the judgment.
Okay, okay.
You say that as a final adjudicating authority is overlooking of a certain factual aspect will constitute a substantial question of law. Yes, Mr. Anas Gupta, please be allowed 2 weeks time
Okay.
to come up with authorities to substantiate the suggested questions.
Substantial questions.
Yes, substantial question.
Deep.
Okay, much obliged.
Yes, Mr. P.T. Sama.
Please, Lordship. Lordship, here I am praying for recalling the record from the judges, because the main allegation here in the specific pleading also is here that the private respondent succeed the writ appeal as well as writ petition as well as the writ petition by submitting the fact document. They have tempered the document Whereas to that effect also we have filed the FIR. The FIR also the preliminary.
What do you mean by tampered with the document?
The document there is that this appellant, I mean the repetitioner before in the single bench, they have enclosed the genealogy.
Where was the private respondent?
There is a specific
There
pleading
is
on page 224, my
Your
lord.
application.
This is a review application, my lord.
Review application.
Yes. Yes.
Therefore, I am. This may I just. Therefore, my prayer is just let the record me be called for, so that we can I can substantiate if they are not able to produce that. There should have been two documents, because there is a specific pleading in the page 224. They have mentioned they asked for the original record. It should have been written as Mara.
What will able to follow you? You want us to be like a forensic laboratory or something to check tampering?
That tampering, that record, calling of record is very important, my lord, because that specific pleading is there where the genealogy tree they have enclosed the tempered document, my lord. That is the.
How are we going to that?
That was even
Mr.
pleading
J.
was there, lordship.
You heard the prayer of your learned friend. Yes. What do you have to say?
But even if we produce a record, can this honorable court ascertain whether the record was tampered or not? To produce the record, there is no difficulty, my lord. But whether my lord will.
For the
take
interest of
evidence in this
justice,
matter.
lordship, because I'm not, but there is FIR also, my lord.
Yes. So we'll do one thing. This is for admission hearing today. You're prepared.
This is actually admission.
Actually for?
Admission on the last.
Yes.
I filed a miscase for delay, but the law has given expression that delay can be condoned, then we will go on.
There's no question of condoned delay. You have to show that
Yes.
reasonableness. Okay. We take the spirit CPC. Okay, 30 days for review. You have come a 1645 days. Okay. Even if we overlook that, what grounds of review have you made out?
Yes, that are only the ground what I.
You know what are the three basic grounds for review, correct?
Yes.
Then just show us those where you do in your review application pleadings you made out those grounds.
Give me some time, lordship.
What time? We'll give you till after half an hour.
I'll prepare those grounds, lordship.
You don't know that there are three basic grounds for review. So you have to satisfy the court that these grounds, or maybe one or two of them, are met. That are apparent phase record, new materials. Now, what you are seeking to, what you call, argue, is that there was some forged document which was used by the respondents.
Yes.
On the basis of which, some name was entered in the genealogical chart, correct?
Yes.
And then on the basis of that, those findings were arrived at. Is that a ground for review?
No. The entire genealogy had been completely changed,
Yes.
tempered. We have the
Then there's
original
no ground for
document.
review, then we'll dismiss it.
Not, your lordship. I'll satisfy that even those ground. So you give me some time because it is so
Okay,
so
after,
perky.
after Christmas.
For interest of justice, because
Interest of justice will give you time. We're ready to hear the matter now.
no, I'm not fully prepared, my lord. I'm honestly speaking, because I don't want to just spoil my cases also. Just give sufficient time so that I can prepare where, because this is it will take time for me also to go through.
Okay. Mr. P.D. Sama prays that the matter be adjourned to enable him to
Prepare.
prepare to come up with authorities. We'll just say that.
Yes, yes, lordship.
Lawyers always supposed to be well prepared with the matter.
Yes,
Right.
lordship. Sorry. Then matter may come after 2 weeks, my lord.
Yes, okay, 2 weeks. But remember the three grounds of review.
Lordship.
Meet them. Yeah.
Much blessed, lordship.
Your Lordship, the senior is appearing online.
Is he arguing the matter to?
May I please allow?
Yes, Mr. Ghosh.
Yes, Lord. Today I only wish to point out two things, or rather three things. A, in respect of the monies that they had extracted, they have refunded. So I wanted to bring that to my Lord's
Very good.
They have refunded the money. So I wanted to tell that. Second, my Lord, there is a written submission that we have prepared, which we would like to officially hand over to this court. If my Lord recalls that I had about 11 volumes and I had promised and assured that I'll concise it into one document which has everything. So that is available. My colleague will just hand it over.
So we can disregard. We can disregard those 11 volumes, Mr. Ghosh.
Not necessarily. It has cross references. So then, if my Lord feels the need to go back, then my Lord can go back because I've given the page number also and the volume number.
So you mean it's just a illustrative index of the compendium?
Index plus content. I'll just
Yes.
point it out. Let my learned friend bring it.
This is the one. Yes.
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 So on the first page there is an executive summary. I'll just take my Lord to the index, so my Lord appreciates. So first is an executive summary. Serial number 2 is the legal framework related to development national highways, all those statutes that govern it.
Right.
Third is the concession agreement that we have.
Yes.
The contents of a concession agreement. Fourth is the deliberation of the GST Council, the first one, to put a second GST Council through which they propose the exemption. Fifth is subsequent development of the issuance of the impugned circular after 4 years, my Lord recalls. Sixth is our factual ladder of how the matter traveled to this court, round 1 litigation and round 2. Seventh is the proposition of law, 8 principles governing alternate remedy, all the principles, law, case laws. 8 is how we fit into all of them. Serial number 8, how do we fit into all those 8 principles of alternate remedy exception? 9 is on the validity of 14 of 2017. This is the proper officer who, whether he can issue the show cause notice, whether he was a proper officer.
Yes.
In that, there are 4 sections. First one is whether central government could have effectuated any such investment of power because they had the power to appoint. The issue is whether they could have invested. That is the part of all the issues. B is rebuttal to the submission of the union in this case. And C is the fallacies in the judgment of the Allahabad High Court in this RC digital, infra digital. I've dealt with them. And D is rebuttal of state of Meghalaya on this particular. Then 10th is the validity of the circular, which is that proper officer for adjudication purposes, because it was supposed to have been issued by the commissioner in the board, whereas it has been issued by the board. So that particular aspect. And the rebuttal to the union in the Meghalaya state's submission. 11th is the validity of the circular dated so-and-so. This is on the merits that SSC code this versus that, because that became the very basis on which the show cause notice and the order got passed. So the validity of that circular, this is the same circular that Karnataka High Court had quashed. And the rebuttal thereof. Then on merits, serial number 12, why petitioner is eligible to exemption and this SSC code so-and-so versus so-and-so, that controversy. The 3 fallacies in that submission of the state as well as the OIO. What are the 3 fallacies in that? 13 is the true nature of the function that I discharge. This is the public function, operating part and traffic regulation, the judgment the Supreme Court had quoted. And the rebuttal. 14 is this composite scheme that my learned friend from the state of Meghalaya made a mention about. So a rebuttal of the composite supply. 15 is rebuttal of those 3 decisions that they relied upon. One is that Andhra Pradesh High Court GMR Pachampalli, which was reversed by the Supreme Court, saying that you can't rely upon that on merits at all. Then Dilip Kumar, which I have distinguished by Mother Superior, that's a subsequent decision that look at the purpose of the exemption. And then this AR that my learned friend had placed before me. Then 16th is this without prejudice argument that they have no jurisdiction to levy because it's a construction activity to complete it prior to introduction of GST. This is the whole thing 2014 that you have no power to levy tax on a retroactive basis. 17th is that they have no jurisdiction to levy tax on sale of land because I had said highways is immovable property and it gets transferred at the end of 20 years. The Anant Mill judgment of Supreme Court. Then about 18th is NCLT order, that immunity that was given for that 1 year period, that NCLT thing. 19, my lord, is something that I had not argued and I may be permitted to raise this, touch upon this particular point because my lord recalls what happened was this highway partly is in Meghalaya and partly in Assam. Now the state of Meghalaya cannot have jurisdiction to levy tax on the portion of the highway that is in Assam.
How do you discern that?
Yes,
What?
the CGST rules provide that the proportion of the value of the asset in the state of Meghalaya, the Meghalaya will have the power. To the extent it is in Assam, Assam will have the power. I'll just point out in my writ petition the particular paragraph. So that is one thing that I need to
How
touch
could be
upon.
possible if project
That apart
from
from
Meghalaya only?
I wish to
Yes, please continue.
I wish to rebut three submissions of the state of Meghalaya at the last date, which is why I wanted to make this submission. My learned friend says that, for a minute, Bella, take the CGST Act, section 291.
One second.
Yes.
Today, 18th, right? Yes. Yes, section 21.
Section 291.
291, right?
Definition clause 2
Yes.
91.
Yes, proper officer again.
Proper officer.
Yes.
Our case has been all along that proper officer is the central tax officer who has been assigned that function. And I'll read out, proper officer in relation to any function to be performed under this act means the commissioner or the officer of the central tax who is assigned that function by commissioner in the board. Now, my learned friend's submission is that this is only a definition clause. Through a definition clause, there is no concept of any enabling function entrustment. Definition clause has to be read as is. It can't be said to be the be-all and end-all for conferment of jurisdiction or conferment of an entrustment as the definition clause reads. So he says this entrustment or assignment that is there in 291 will have to be ignored because it's only a definition clause.
So what's your submission on that?
Yes. Look, this argument found favor with the Supreme Court. In the case of Contempt, well, take volume 2 of my compilation. If my friends can give volume 2 of the old compilation that I have submitted. This line of thinking was found favor with the Supreme Court under customs.
Mr. Ghosh, if you are now advancing with fresh submissions, because there will be just then they will have to reply to your submissions again. It will be a never-ending process.
This is a rebuttal to what the state has submitted. This is a rebuttal to what the state submitted on the last occasion. That is why I am making this point. So
Yes.
Page 37 of volume 2. Canon India.
That is volume 1.
Oh, this is the wrong volume.
That is volume 1, Your Lordship.
Volume 2. This one.
What he's referring to is volume 1.
Volume 1. I'm so sorry. Volume 1. I'm so sorry.
Yes, Canon India, 37.
Yes. Yes, this is a 2021 decision, page 37.
Yeah.
And if my lord comes to page 40, para 20, the argument that the state advanced, did find favor with the Supreme Court at para 20. I'll just read. It appears that the Deputy Commissioner or Assistant Commissioner of Customs has been entrusted with the function under section so-and-so white serial above. By reason of the fact that the functions are assigned to officers referred to in column 3 and those officers above the rank of officers mentioned in column 2, the Commissioner of Customs will be included as an officer entitled to perform the function under section 28, conferred as Deputy Commissioner or Assistant Commissioner, but the notification appears to be ill-founded. The notification is purported to have been issued in exercise of powers under section 234, which is the corresponding 234. This section does not confer any power or on any authority to entrust any function to the officer. The subsection is part of a definition clause of this act. It merely defines the proper officer. So section 234 of customs were very similar to 291 of
Right.
GST. So therefore Supreme Court took a view that definitional clause cannot be used for entrustment.
So how do you distinguish this? How do you distinguish this then?
Yes, and this is what I am pained to say, that the state is submitting judgments without telling this court what happened thereafter. This judgment was reversed in review. This judgment was reversed in review, and the review is at Millard, the SCC hard copy. I have requested the court master to submit it for Millard.
This is given by who? This compilation by you? No.
This
You didn't. You have not cited this judgment.
I have not.
They have not cited this judgment, Mr. Ghosh.
Lord, the argument was
Argument is yes, and they have advanced arguments, but they have not substantiated with any judgment, as you say. That's incorrect. Yes.
right. So now, if Millard takes the SCC, the hard copy, I have requested the court master to submit. If Millard comes to page 509. At page 509, this belongs to a review order by 5 learned judges, reviewing the earlier order of 3 learned judges. If Millard comes to para 130,
It's 3 judges, not 5. It's 3 only.
the review is, sorry, by 3 judges. Yes, it was reviewed by 3 judges. Earlier it was 3, it was reviewed by 3. My apologies. Now, Millard comes to page 587, para 130. Three paragraphs where they overturn the whole concept on that definition clause cannot be used for entrustment. Now,
Yes.
page 587, para
Yes.
130.
Yes.
The assignment of function of the proper officer for the purpose of any section under the Act to an officer of customs is expressly mentioned in section 234. Section 5 empowers the customs officer to discharge the duties of proper officer so conferred
Yes.
through 234. Even prior to the amendment to section 234, this could be the only understanding with respect to question of entrustment of function of proper officer to a customs officer. In our view, the assignment of function of proper officer as mentioned in section 234 and entrustment of function of customs as mentioned in section 6 operate on different phases. Please, the assignment of function of proper officer is to be done only to the officers of customs, whether they be appointed under section 4 or entrusted with certain functions under section 6. There may be some overlap between the assignment of function of proper officer under 234 read with section 5 and the entrustment of function of officer of the customs under section 6 in some instances, but there can be no scenario in which you can hold that the functions under section 6 and 234 are congruent. One of the bases for the decision of Canon India, the original one, was that no entrustment of function under section 6 was done in favor of DRI officers. This, however, is a glaring misapplication of section 6 of the Act and is in ignorance of applicable law, which is in fact section 234 read with section 5. So therefore, Supreme Court clearly said 235 is the source of power for entrustment. And
234.
earlier think that it's, yes, 234 is the customs similar provision to our 291. In fact, 234, my lord, will find that in volume 2.
It's okay.
Page, yes.
Have you seen that?
Same thing. Yes. So therefore, if there's a fallacy in saying that the definitional clause cannot be used for conferment of power, definitional clause has been, and the subsequent decision of Supreme Court so confirms. So that is one way. The second thing, my lord, my learned friend has made a point that apparently board and the customs and the central government is one and the same, that RC infrastructure judgment. If the central government can do, if the board can do, why can't the central government do? Why can't the central government?
Yes.
In my written submission, if my lord comes to page 78.
Yes, 1 second. 1 second, just give some.
Yes, my lord.
This is yes.
If my lord comes to page 78 of the written submission.
Yes.
I have given the illustration under the Customs Act at para 9.44 at the foot of the page.
Yes.
Just to explain before I read it out. Earlier, under section 4 of the Customs Act, the power to appoint officers was with central government.
Yes.
I'll read section 4, just at the foot of the page.
Central government may appoint him.
May appoint.
Yes.
Okay. Then, pursuant to that, the very next page, notification number 17 of 2002 was issued.
Yes.
In exercise of powers under section 4.1, etc., supersession, so and so.
Board is used substituted in place central government.
Yeah.
Yes.
Yeah. The central
Then-
government appoints.
Yes.
Then 117 Finance Act 2002 came to be enacted. There the word
Board.
central government was replaced by the word board.
Yes.
Pursuant to that, 40 of 2012 was issued, and the power was exercised by the board in the very next
Yes,
in the
yes.
in the page 70, page 80.
Yes.
This goes to show that if the proposition of law is that what board can do, central government can do, then there is no need for this amendment. The
Okay.
very
Yes.
fact that from central government they have moved to board and a separate notification comes by the board goes to show that in the eyes of the parliament they are two different bodies.
Yes.
Otherwise, this amendment will become defunct. What's yours?
Yes.
So therefore, this was something that I wanted to point out for Milord's consideration. Apart
Right.
from the Rupchand judgment that I had quoted, that delegated does not have any plenary power. That judgment I had already quoted.
Your next point. Next rebuttal.
Yes, next is rebuttal. My learned friend says that appointment and investment are subsumed.
Yes.
Once you have the power to appoint, power to investment comes as a matter of course.
Yes.
Now, my lord, in my written submission, I had given copious distinction between the two at page 67, my lord sees.
Yes.
Page 67, para 9.25.
Yes.
It is also well established principle of law that whereas statute uses two different phrases, words, then they mean two different things. These illustrations are important. While section 341 and 61 of the CGST Act uses the phrase appoint, section
Yes.
291, 42, 61, 67.1 and 67.2 thereof uses the word authorized or assigned. Under these circumstances, even the statutory scheme admits of the fact that the words appoint and authorized or assigned, which is nothing but investment of power, are not one and the same, and they are distinct. And I've quoted some judgments, my lord, that substantial and etc. etc. And my lord, kindly also come to page 66, para 9.20.
1 second. Nine.
Page
Page?
66, page 66,
Yes.
9.20.
Yes. Appointment and investment.
That's right.
Yes.
And subpara 9.20 is what I'm referring to. It is respect to submission of the petitioner that the word appointment and investment of power mean two different things and cannot be treated as either synonymous or one being subsumed into another. Distinction between appointment and vesting of power is well recognized in legal parlance as per Black's Law Dictionary. Here will not be refer volume 2, page 2 of volume 4 of the compilation. This is where Bellot may have to cross-refer. I've given a reference. The term appoint means to choose to designate someone for a position or job, especially in government, whereas the word invest is defined in page 5 of volume 4 to supply with authority. So therefore, the legal definition has also been there. One judgment I at that point in time did not quote, and I thought now it becomes relevant. Bellot will come to page volume 4, page 274. Because since this submission was not raised, I did not deem it fit to trouble Bellot. But I think now it is relevant that I raise this.
Yes. Page.
Page 275, volume 4.
$275. Which judgment is this?
Constitution bench, yeah, Constitution bench judgment, Jamshed and Guzdar.
Yes.
I'll just explain briefly what the issue was. It was a case where some of the jurisdiction of the High Court was carved out and given to civil court. And the contention was that this kind of carve out could have been done only by the parliament, not by the state government. So what fell for consideration before the Supreme Court is whether constitution of the High Court subsumes conferment of jurisdiction, which is very similar to what we have. Appointment whether it is subsumed jurisdiction, because assignment or authorization is conferring with jurisdiction.
No
It is in this
application.
context the judgment was. But we come to straight away to page 287,
Para.
para 10. Well, in para 10, Placitan G may be taken.
Yes.
In the interest of time, I'm crunching it.
Yes.
Placitan G, the word general jurisdiction, will see that?
Yes.
Just above that, according to the learned senior counsel,
Yes.
the general jurisdiction of a civil court as opposed to its special jurisdiction in respect of a particular subject matter relates to the constitution of a court and flows from the very act of constituting it. Thus, the general jurisdiction of the High Court is the subject covered by 1878 of List 1, falling with the exclusive legislative competence of the Parliament. On the other hand, the general jurisdiction of a court other than Supreme Court and High Court is subject that of under 83 of List 2 prior to the Constitution 42nd Amendment. Then when it comes to para 11, learned senior counsel also argued that constitution of a court of law necessarily includes this general jurisdiction, same as appointment includes subsuming of authorization. No court can be constituted without jurisdiction. Jurisdiction and constitution of a court are inseparable. Otherwise, it would be an ineffective institution in name only. The ordinary dictionary meaning of the word constitution of a court is sufficiently wide to include the jurisdiction of a court. In common parlance also, if a court is to be constituted, it must necessarily be constituted with its heart and soul, namely its jurisdiction. Constituted a law in its true content and purport related jurisdiction of High Court can only be made by the Parliament. Then my lord goes to para 21, which is at page 292. This is where the Supreme Court appreciates the contention.
Yes.
Para 21, we have carefully considered the rival contentions. Then Lord goes to para 36, which is at page 297.
Yes.
Para 36. Now, this is the heart. In considering the legislative competence of Maharashtra state in enacting the 1987 Act and 1986 Act, primarily we have to look to the relevant entries in the 7th schedule to the Constitution. Now, 77, 78 is important for list 1. 77 says, Constitution, organization, jurisdiction and powers of Supreme Court, including contempt of such court and fees taken therein, persons entitled to practice before Supreme Court. 78 says, Constitution and organization, including vacation of the High Court, except provisions as to officers and servants of High Court. So 78 did not use the word jurisdiction, unlike 77 did. Kindly see, Constitution, organization.
Yes, we've seen that. We've seen that. Yes.
Then when it comes to list 2, just below that,
Yes.
entry 65.
Yes.
Here they say jurisdiction and powers of all courts except the Supreme Court.
Yes.
So they distinguish between the two. Then at para 46. Para 37, the next page. As is clear from the entries extracted above, entry 77 in list 1 deals with the constitution, organization, jurisdiction and powers of Supreme Court. Entry 78 relates to only constitution and organization of the High Court and not with the jurisdiction of powers of the High Court, unlike in entry 77 dealing with the jurisdiction and power of Supreme Court in addition to constitution and organization. Jurisdiction of powers of High Court are dealt with separately in separate topic, etc., etc. Then para 38. In our view, the state legislature has power to confer general jurisdiction in all the courts except the Supreme Court under 11A of the concurrent list falling under meaning, etc., etc. Then para 40. Then comes the real crux. From careful reading of 77 and 78, entry 77 and 78 of the union list, it is clear that entry 77 not only deals with constitution and organization, but also with jurisdiction and powers with respect to Supreme Court falling under exclusive domain of the Parliament. And section 11A of the concurrent list deals with the administration of justice in all the courts and the constitutional organization of all courts except the Supreme Court and the High Court. Thus, it is clear that Parliament is the sole repository of power as far as constitutional organization and jurisdiction of power as Supreme Court concerned. Conscious omission, kindly see this word, conscious omission of the word jurisdiction and powers in 1978, looking to the said words included in 1977, it is clear that jurisdiction and powers of High Court are dealt with as a separate topic under the caption Administration of Justice. Entry 11A of the concurrent list, that exclusion of jurisdictional powers from entry 78 appears to be meaningful and intended to serve a definite purpose to the relation to bifurcation or division of legislative power. As an analogy, conscious omission of the word investment in section 3 and conscious inclusion of the word entrustment in section 291 makes it abundantly clear insofar as the parliamentary intent is concerned. That's the argument. Then, my lord, para 41. My lord, in placitum D, the words are law.
Yes.
Placitum D, 3 lines below that.
Yes.
The word is matters.
Yes.
The word constitution and organization have their own meaning as against the expression jurisdiction.
So your the whole class argument that a point different from assign and investment different from appointment. That's it. Investment and yes.
This judgment goes to clear that. In fact,
Okay.
Para 42 at page 300. Let me just read that one line and it should be very clear. Para 40 at page 300 opening line.
Page?
So page
Okay.
300 start page 300.
Okay. Para 42. Para 42 is at
Yeah, it starts at 299 at 300, the first line. Constitution of the High Court.
yes. Yes.
This is the real crux. It is not possible to say that investing the civil court with unlimited jurisdiction, taking away the same from the High Court amounts to dealing with the Constitution. And organization of the High Court under 80, so also the legislature is empowered to constitute and organize the civil court, and while constitute such court, the state legislature is so also empowered to confer jurisdiction. So clearly they say investing is different from appointment or constitution.
Right.
Then about para 49. Well, I need not cover the part.
Right.
So I think this is where I rest. So therefore, this judgment and the constitution bench judgment makes it very clear that appointment does not subsume jurisdiction. It's two different words. Basically, the scheme of our act also there are two different things, as there are different sections that are using different words in that context. But the other thing, my lord, my learned friend pointed out to section 3. If my lord take section 3 of the CGST Act.
This is your last rebuttal.
Yes, my lord. Last rebuttal. I will not trouble my lord any further. I have troubled my lord a lot.
Yeah. Section. Yes, Mr. Ghosh. Officers.
Lord, yes, officers. My learned friend appearing for the state showed section 3 of the CGST Act, showed that serial number E, Additional Commissioner of Central Tax is written, showed that the Additional Commissioner of Central Tax is the person who has passed the adjudication order, therefore came to a conclusion that he is a proper officer.
Yes.
The fallacy is section 3 only deals with appointment of central tax officers, not proper officers. We kindly read section 3 once again, my lord. Officers under the act. It doesn't say proper officer under the act. That's one. The government shall by notification appoint the following classes of officer. There are only classes of officer without any power or function. The functionality, jurisdiction, power comes from 2991. So mainly because the name of the gentleman may be here, he is only a central tax officer, no difficulty. But to be a proper officer, which is at an echelon higher with a proper power, conferment of power, it has to come from 291.
Yes.
So this was what. Now on the Meghalaya thing, which I did not argue, and my apologies. If my lord takes the writ petition for a minute, page 108, Meghalaya Assam, that distinction my lord asked, how do we differentiate the two?
Writ petition 108.
Writ petition, yes, sir.
Yes. If we argue this now, Mr. Ghosh, then we have necessary to give them also the chance to rebut your contention, which you'll raise in this last rebuttal. Are you proposing to go ahead with it? Is it very crucial to your case?
It is crucial, my lord. It's crucial. I'll tell you, my lord, why. Out of 110 crores, and assuming that I'm not able to persuade this honorable court, if my 110 crores comes down to 50 crores because of this divestiture, then it is still a relief for me. Because otherwise it will become a constructive res judicator.
That should have come up. It should have been argued earlier. Yes, Dr. Mojika, what do you have to say to this?
This will only affect the state, as far as we are concerned.
No, the state. What does the state have to say?
After hearing from the Learned Council,
you understand what he's? I mean, like what he's trying to submit. Because yes,
if that is the case, well, state of Assam has to include as a party.
Exactly.
We'll come back to.
No, the state of Assam need not be, because that's an independent cause of action. They'll have to initiate a cause of action separately, independent of this.
No, the state of Meghalaya.
Well, see, we have to come back to the project propounder now, and to what it would a very genesis of the entire project of this Jorabat Expressway. As what is, if you want to see incidents of where it will fall.
As far as this case is concerned, my lord, includes both CGST and SGST, my lord. And there is no
for central central GST, no difference.
Yes.
Now you want to what do you call it, bifurcate it and make it into a smaller issue with regard state. Then that'll complicate matters for the whole.
Assam has to include as a party, to reheard the entire matter.
And petitioner, my lord, is registered here in the state.
And where you registered?
Meghalaya.
Well, I'll explain. I am registered in the state of Meghalaya, no difficulty. The law of CGST says, in respect of work done on immune property, power to levy tax or place of supply will be to the extent of properties located in the state of Assam or to the extent the property is located in Meghalaya. There is a rule prescribed under the CGST rules to ascertain how it is to be done. For example, if there is a pipeline that way to be established from Guwahati to Meghalaya, state of Assam cannot tax the whole thing. State of Meghalaya needs to get a revenue for that. Similarly, for this pipeline going from Meghalaya to Assam, Meghalaya cannot say, I'll take the whole revenue for Assam. That's the law.
Can you show the writ petition where you made a pleading?
Yes, Philip. Kindly have page 108 and then I'll take you to the writ petition.
108?
Yes.
High Court.
Writ petition number 1. Undisputed facts.
Oh, sorry, sir. Yes. Is there any pleading with regard to the incidents?
Yes. There is a pleading. And it is my mistake, my lord. I take the responsibility.
Yes, Mr. Ghosh, but we have travelled down the road now far enough. Then now we don't want to make a detour, and lead us to.
Yes, I understand. Now kindly see page 108. It is part of the order in original.
Right.
1, 2, 3, 4th line from bottom of para 1.1.
Yes.
Now the word starts with the word entering into concession agreement. My lord sees that.
4 lines.
4th line from bottom.
Yes.
They are presently engaged in development and operation of the existing road of kilometer 0 to kilometer 61 on the Jorbat Shillong Barapani section of National Highway 40 in the state of Assam and Meghalaya for 4-laning of road on design build.
Now let's come to the brass tacks. Now who maintains the road from Jorabat to the entire highway?
I do.
From this concession that you received from state of Meghalaya.
Yes. And now my lord may take page 74 of my writ petition. Round 7.
Yes.
The state of Assam, go back to 0
Incidents. Yes, Mr. Ghosh.
Para 131.
Yes.
Impugn order proceeds on the basis that the concession agreement is in a sense a construction agreement. Consequently, as per the impugned order, the construction of Project Highway is carried out across the territories of Assam and Meghalaya. The purported construction services are therefore dispersed across 2 states, and the legal position governing the status of such services is elaborated below. The IGST Act provides for a comprehensive scheme for determination of nature of supply and place of supply. In terms of section 12(3)(a) of the IGST Act, the place of supply in respect of services directly relating to immovable property is geared to a location of the immovable property. The explanation appended to section 2(3) of the IGST Act clarifies that in instances where the immovable property is dispersed across multiple states, the supply of services shall be prorated as per the value agreed or as may be prescribed. The concession agreement does not contemplate any demarcation of the consideration in the form of annuities between 2 states, Assam and Meghalaya. Absent such contractual demarcation, gainful reference is made to the prescriptive provision set out in Rule 4.2 of the Integrated Goods and Service Tax Rules, which prescribe that the place of supply shall be determined in proportion to the area of the immovable property lying in each state. Illustration 2.
Have you had other similar cases where this has happened, where there's interstate but it's considered one project intra-state only? Are there any other instances? Are there any other cases? I'm sure there must be, because there are projects all over India.
Yes.
Well, GST being in a nascent state, some of these litigations are just about happening. This
No, I mean regarding, I mean you're raising a new dimension altogether, if we can say that. With regard to, we have to discern whether it's intrastate or interstate, and whether the concession is intrastate or you can take it to be interstate. Then you have to satisfy the court that it's interstate, if your argument is to hold good. What is it?
So I have given that.
It becomes a bit difficult, Mr. Ghosh, to, I mean, at least to proceed with this argument.
Then Milord, I will not press this point any further. Let it be the way it is. It is written in the writ petition. Milord may say that this point was not argued.
Yes.
I don't want to trouble Milord. The idea is not to trouble Milord. Milord may say it was recorded but not argued. Milord may.
But it should not go on appeal that, this point was argued and not appreciated by the court. It's a substantial question of law with regard to whether a concession was intrastate or interstate. Now that will put us on the back foot also.
It was my duty to point
It doesn't cut both ways. Shouldn't cut both ways. Yes.
Because at page 76 of writ petition, basis the
Right. We don't. Yes, granted. No quarrel. It's there. Your pleadings are there. Yes. But that is why, if you can just give an instance where this has happened, that's all. In other parts of the country, that's all.
Under VAT or sales tax, I have experience, personal experience of, because at that time.
So regarding, irrespective of what the school is trying to say, is whether such instances have occurred in other parts of the country where there is interstate, projects going on under this HIDC or whatever. So whether what is the mechanism that they adopted there, when it's interstate or intrastate?
Because they follow the law to say that it will be a proportionate. My learned friend may present the IGST Act, section 12(3).
No, we're not going to act. We're talking about particular instances that have occurred, and how has the law dealt with it?
No, I don't want to make a statement because I am personally I have no knowledge about in reality whether any such cases have happened.
You kindly find out.
Right. But at the same time, what is equally important is under the sales tax law, I have had personal experience as a counsel. At that point in time, I used to go for tax assessment on the ground. The Kandla-Bhatinla pipeline project, which started from the state of Gujarat, went through Punjab, Rajasthan, and Haryana. 4 states. It was a works contract or construction contract that was carried out by a Czech company for IOCL. The sales tax liability was imposed by the 4 states based on the length of the pipeline within their state. Because the territorial nexus to an immovable property or the work done is integral to a state's power to levy tax.
You understand that Jorabat Expressway, it's the left side is Assam and the right side is Meghalaya if you come from Guwahati. So how do we go about
That is the start point only, the Jorabat area only.
No, in fact, in my pleadings, I have at page 76 I have said, I'll just explain.
No, that we've seen your pleadings. We're not saying we don't have a quarrel with you not putting it in your repetition, but whether how do we discern this particular, it's on realistic terms with regard to whether you want us to go into that area.
I don't want to, very well, my lord, because the quantum of work done in Assam is just about 5.58%. It's not the whole thing. I mean, I pleaded so at page 76. Let it be, my lord. I will not.
So anyway, we'll close the arguments now. That is it, Mr. Ghosh.
Yes, my lord. The only thing is this may be permitted to put a supplementary one-pager to bring out the summary of the submission that I made on that Gujarat judgment, my lord. The Supreme Court.
Yeah, another thing, if you could assist the court and you could give the entire your compilations in a pen drive, so it'll be easier for us to cross-reference without opening the pages.
Very well.
You kindly do that.
So,
By
the written, yeah.
the written note and the I mean all the whole compilation. You kindly give it in digital format.
Yes. I'll just amend the compilation that I just handed over by putting that new judgment that I just put in, which was the new which I had not put in.
When can you do it?
I'm so obliged. Will you reserve the judgment, Lord?
When can you do it? When can you provide the note? I mean your
within
most of the day.
3-4 days. 3-4 days.
With the thing, no, we're not going to go through the entire 7. Like we have to cross-reference, so it'll be easier for us to.
Right.
Yeah.
Well, we'll also file it within.
The hurdle is come is Meghalaya and Assam now. It's a major hurdle.
Not pressing, that.
You're not pressing it.
Can order be passed to the prejudice of state of Assam without imitating them?
No, like I said, the DSG will appreciate. I am not pressing it. It's there in the writ petition. Let it be there. And anyway, it's 5.58%. There are larger issues that I have raised. If I'm
and if you do that now, my lord,
yes,
you have to go back to Jorawat and start from there again, will it?
We don't want to live a full circle on this point. Mallards have been very, very, very patient with me. And
yes. No, because for us also we're learning something new. So that's the thing. So we also, that way grateful.
From my side, Lord, I have tried my best to assist the court from all angles, not restricting myself to only tax law. I've tried to bring in as many jurisprudential law that is possible, and I leave it to my lord.
Thank you very much. Yes. So we conclude the hearing.
My lord, we'll also file it within.
Yes, hearing parties to submit additional notes and submissions if necessary, as also compilation on digital format. Yes, hearing is concluded. Judgment reserved. Yes.
But we have to file our.
Yes.
Well, I'm probably a little longer time. 2 weeks time.
Okay. Then we can't reserve it right now. Then we have to list it after 2 weeks. Yes, after 2 weeks of filing of.
We'll file it. Yes.
Yes, we'll record order for hearing for like what do you call it? Parties to submit their notes and their notes on submissions.
Hearing concluded.
Also the compilation and digital format. You have a compilation also? No.
I submitted along with my written notes. I'll submit.
Yes, this after 2 weeks. Yes.
The hearing concluded. Hearing concluded. We record.
The hearing is concluded. This after 2 weeks.
And my lord, my apologies. I want to come physically today, but unfortunately, because the confusion between 10:30 or 2 o'clock.
Oh,
I have
yes.
to be in Chennai, Madras High Court tomorrow, so therefore I couldn't fly my colleague.
Very well. No issues. No issues.
Deep.
Like,
Any mention?
Hey, please, Your Lordship. Lordship, I beg to make a mention of item 59, Lordship. Lordship, I'm praying if this matter may come up after a week's time. I've informed the State Council's Lordship.
Who's for the state? Yes. Yes.
Lordship, a similar prayer for item 66, Lordship.
Why? He has no objection.
No objection, Your Lordship. Highly obliged, Lordship.
Please, Lordship. I beg to mention item number 64.
Yes. 64.
Yes, Lord.
Lakhan Prasad.
Yes, Lordship.
Who's for the petitioner?
Lordship, Mr. SN.
Mr.
SN. Lordship, we just received a copy of the rejoinder yesterday, last evening, Lordship.
We file a rejoinder, detailed rejoinder.
After 2 weeks.
Lordship. Obliged.
Yes.
Please, Your Lordship, I beg to mention item number 58.
Why?
Your Lordship, we are yet to file the rejoinder.
You can't file the rejoinder to the affidavit filed by the state.
We'll be filing, no, Your Lordship, we'll
Tomorrow?
file after 2 weeks.
Tomorrow or 2 weeks?
After 2 weeks.
2 weeks. It's okay.
Any interim order?
No, madam.
After 2 weeks. Yes, after 2 weeks.
My Lord,
For rejoinder. Yes.
I beg to mention, my Lord, item number 67. If this matter can be listed after 1 week, my Lord.
67. Whose other side?
Yeah, that's the respondent.
Second, their
Any
consent.
objection?
No objection.
Finish up this matter.
Yes, it's trying out. Obliged.
Obliged.
My Lord, I beg to make a mention, item 57 and 62, my Lord. Let it come after 2 weeks. I'll do it after 2 weeks.
57 and
62, my Lord.
Well, 57 is, no, 62 there's a stay order operating, my Lord.
there's a covered case.
My Lord, I will argue this matter.
Most of the cases are
No,
covered.
now my friend has told me,
SHP is there.
no, Manipur High Court has passed some order. I have not gone through that
But
order.
they rely to learned single judge's order of Manipur High Court, and on the basis of that, interim order was passed by the Lordship.
So I asked him to give a copy.
Interfered with that order long time back, man.
My Lord, I have not received it.
After 1 week.
After 10 days, my Lord, after 10 days.
762. After 10 days, yes. On
After
the
10.
request of Mr. M. Chandrai. Yes.
Both the matter, my Lord. Obliged. And interim order to continue, my Lord, till then.
Yes.
Interim order only 62, man.
Only in 62, my Lord.
Yes. Yes, yes.
Please, Lordship, I beg to mention item 60. I'm praying for 2 weeks' time, Lordship, in this matter.
No objection.
No objection. Yes, yes.
Much obliged, Lordship.
Your Lordship, I beg to mention item 63. And being led by Miss Yangi, Your Lordship, she has some personal difficulty. Mrs. T. Yangi.
Any objection?
No objection,
After
sir.
1 week? 2 weeks?
Let it come after 2 weeks, Your
2
Lordship.
weeks, okay.
Can I respond in 6?
Very good, yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 65. I'm appearing for respondent number 6.
Number?
65.
Number 6.
Yes, Your
For the
Lordship.
petitioner?
Yes, Lordship, I am for the petitioner. Your Lordship, for respondent number 4 and 5, the contacting counsel, Mr. Asaling, to inform us to inform this court. He is under bereavement.
Okay, after 2 weeks. Yes.
Much obliged. Highly obliged.
Daily list item number 1.
Yes. Yes. Why you want to review?
Only a limited extent, if your Lordship.
So why review? Last time there was no objection from Mr. Jindal.
My specific objections were that technical member be appointed.
Were you there in the hearing the last date?
Yes, I was there virtually present. But it was argued by
My Lord, the same names were proposed by Mr. Jindal, my Lord. He also has rejected that and appointed
Yes.
Justice. former Chief Justice, my lord. And now, my lord, that's one aspect, my lord. And the second aspect is a review petition not maintainable under Arbitration and Conciliation Act, my lord.
Yes.
No, Lordship may kindly see, I have two judgments of one of the Honorable Apex Court as well as of the Bombay High Court, which says that a review petition would be maintainable. So, Lordship, my friend will tender that judgment, 2019 Volume 3, SCC 203.
Will not record a consent then? We'll send it for arbitration finish.
My lord.
There's a court order for send it to the arbitrator. Will not. He says that the consent been wrongly recorded. What? Your local counsel was here. He didn't object to it.
My lord, no consent is required when they are approaching under Section 11, my lord, and the same names were proposed, my lord, by the council at that point of time. Those were rejected by a lordship. My lordship by your consent.
Rejected.
My lord, our submission was that the panel has expired, my lord, is not been renewed.
Your Lordship,
And they refer to some ICA. And why they are insisting on that, my lord? Same names, my lord, again and again.
No, 10 different names were given from the MEI's panel.
No.
They could have easily selected out of that. If your Lordship has just 2000.
See, in the absence of arbitration agreement, then it'll be then the review you can file. Where's the optive part?
Yes, para 10 if your Lordship.
Yes.
Insofar as the High Court jurisdiction to recall its own order is concerned, the High Courts are a court of record.
No, forget about that one. What are the facts of the case?
Now, in this facts of the case, if you Lordship see that para 2.
You give a copy to the other side.
In this matter, if your Lordship
See, so you see, the thing is that for dispute arbitration, no arbitration is allowed. As 13.1, this the judgment is not applicable. Next judgment.
Next judgment, if your Lordship sees the Bombay High Court judgment.
See, in this case, you're citing Mr. Devani. The thing is that he has no cause of arbitration. Yes.
My only limited prayer is, if your Lordship sees, insofar as my insistence is for technical members, because even if they say that the
How are you impeaching the character of the arbitrator that he cannot he cannot give the matter? Then
Lordship may kindly see in my application.
now regarding what is Bombay High Court judgment, which paragraph?
Para 13, if your Lordship sees.
No, this is different. This is regarding the words replacement Chief Justice. Yes.
No, Lordship, their objection is that the Section 11 arbitration petition review is not maintainable. That point has been exclusively covered by this judgment.
But I'm placing 3 reasons, my lord. So section 11 order is not reviewable. I'm placing 3 reasons.
You have it with you?
Yes, ma'am. The first one is a very short decision, my lord.
Yes.
From Kerala High Court. This petition is filed for seeking review of an order issued by the nominee of the Honorable Chief Justice of this court. There is exercise power under Section 11. The said statute is a comprehensive one and is not one which confers power on the High Court to pass any order under Section 11. The power is with the Chief Justice of the High Court to take such measure as may be necessary when request for such measure is made in relation to any arbitration which does not relate to an international. The Chief Justice is empowered under Act to have a nominee which may be even an institution dehouse the High Court. Therefore, it is crystal clear the request under Section 11 does not lie to the High Court. Even when a judge of the High Court acts as the nominee of the Chief Justice, he acts as the pure statutory authority designated by the Chief. Therefore, unless a power of review is expressly conferred under the Act, the general power of review as may be available to the High Court under other jurisdictions so and so cannot be extended to review.
Next judgment?
Our next judgment is from Delhi High Court, my lord.
Which paragraph?
Para 57, my lord.
Para?
57, second last para.
Yes.
To sum up, firstly, the review petition is not maintainable under so and so. Then Calcutta High Court, my lord. This is 23. In similar lines only.
Yes.
Para 9 months. This is a complete code and no review is maintainable. Para 11. Para 9 months.
If a copy is provided to me, I'll also go through that judgment. Because the recent view is that a review petition would be maintainable in view of the 2019 judgment, which has been followed by various high courts. So
2019 judgment is where suppose there's no arbitration clause. Suppose in a contract that is signed with between A and B, it says that it'll go to the engineer in charge or something like that. And if there's no explicit ground for arbitration, then maybe under 11 they cannot file an application of section 9 for no arbitrator. Simple as that.
No, if the Lordship says the Bombay High Court view.
My lord, that is one aspect of the matter. My lord, otherwise also there is no error apparent on the face of record, my lord, to invoke review.
I am only coming up with a very limited request before this honorable court. Now it was at their instance they wanted a panel arbitrator to be appointed.
We'll record, yes, there's an application for review filed by the petitioner in arbitration petition number 6 and 25 on the ground that an error occurred as it has been erroneously recorded that the petitioner's consent to appoint of a non-technical arbitrator has been received. So, Mr. Diwani,
yes, sir.
Yes, has also relied upon the judgment of the Supreme Court in the case of Municipal Corporation of Greater Mumbai and other versus so-and-so session, reported in 2019, Volume 3, SEC 203, where he submits that the court is invested with enough powers under Article 215 of the Constitution of India, being courts of record, to review own judgments. However, it is noted he therefore, as counsel also relied upon another judgment of the Bombay High Court.
Bombay High Court 2024 SEC.
Yes, that is so and so. Oh, sorry, take down. I'll just write petitioner. Where and where? Where is the submission here?
Para 13.
Where has been held that I will a question of actually point out the basic issue in the question of law as it's required management because we get a special and the words you have to handle the case with the words of the court to be the High Court wherein the matter concerned the amendment to section 11. This is also a different fact circumstance also.
No, if the Lordship sees Para 16, the 2019 judgment has been followed in this.
It can only have possessive value. Yes, so-and-so. Tom, which has placed reliance on the earlier judgment cited with regard to the power of review stuff. Dr. N. Mozika, who has entered appearance today itself on behalf of the respondents, has firstly submitted that there is no error apparent in the face record, and has also substantiated and has also further argued that the power that section 11 and submits unless a power review is expressly conferred under the Act itself, the general power review that may be available to the High Court under other jurisdictions can be extended to review only orders. So, in the instant case, it is noted that review sought only on the ground of aforementioned, that is not able to consent. So, this court has perused the judgments cited by the petitioner. It is seen that in the case of Municipal Corporation of Greater Mumbai and other Supra, the matter concerns a dispute where there concerns a contract where there was no arbitration clause. Stop. And similarly, in the later judgment, concerns the prior and post amendment of section 11. Stop. In this, the two judgments therefore have no application to the case of petitioner. Stop. Also examine the decisions referred to by the learned DSGI. Stop. And DSGI, namely, you see decisions. Stop. Where it has been held that the reviews are not maintainable. Stop. This court, after careful consideration, therefore, and the petitioner agreed to make out a case of any error apparent case of court, the application is rejected and accordingly dismissed.
Yes. Supplementary list item number 1.
This is a contempt application.
Which order?
Your Lordship's order.
Assam Rifles?
Assam Rifle, Lordship. I'll take steps, Lordship.
Correct, Mr. M.N. Nauplian and a consular petitioner. If you notice, returnable in 3 weeks, steps were taken by AD in 3 days. Just on so and so.
Item number 2.
Now, what is this?
My Lord, this is a contempt petition by my Lord's order dated 29/10/2025 in WPC number 110 of 25. The respondent number 3 in the writ petitioner, the contemptor herein.
In that case?
Yes, my Lord. He was asked to issue the NOC forthwith. We communicated the order to him on the 3rd.
Mr. Kisi Gautam, Learned Counsel petitioner, issue notice is submitted by the Learned Counsel that the copy of the order stated to be violated, dated 29/10.
29/10
have been served upon the respondent number.
Respondent number 3 in the writ petition.
Bragg contemptor herein on
the 3rd of
on 3/11
on 3/11
25, but till date there has been no compliance thereof. But you take steps in 3 days, just up to 2 weeks.
2 weeks. Obliged.
Item number 3.
Lordship, item number 3 and 5 are those SOP matters, Lordship. I pray that similar orders may be passed, has been passed in other matters, Lordship.
3 and 5,
Lordship. Deeply obliged, Lordship.
4.
4.
Please, Lordship.
Yes, Mr. Sama.
Yeah, Lordship, this I'm working for the period of 33 years as a cashier worker. Till now, they have not regularized my service.
33 years?
33 years. Yet to be.
Working which department?
PhD department.
As what?
Cashier worker. They have neither converted to the regular cashier worker, nor they have promoted to the. There is a provision also.
You're still working?
Yes, still working. Now also I'm in the service.
Where you show that? Where we appointed?
Yes, I have even put my representation also.
So let's see where's your appointment order?
Yes, that.
With the appointment order?
Yes. Appointment order, that's reflected. Page 16, where they have mentioned these. The name of the petitioner. This serial number 87. He joined in service on November, 1st November,
but this is a risk of
October 1992.
Regular casual workers, you're already under RCW scheme then?
Yes, but now it's supposed to promote it to the this group D post.
If there's no vacancy, your number 87, how will you promote it group D post?
No, we allege there is I categorically mentioned in my pleading also. They have never they have this para 5. Where I stated that
Sangma, you know how this system works. Have you shown in a petition how the system works? How RCW is a concept for group D post?
Yes, the group D post is the minimum the page para 5 of my. I have a specific pleading on this one.
Yes. Where have you written? Where have you written that the vacancy is group D post?
I have listened there are many cases who have been served for many years.
No. See, if you have to make out a case,
yes,
please try to understand. You are a regular casual worker, correct? Now, regular casual workers, there are many of them. Okay. Then, under the RCW scheme, this is, I mean, everyone's knowledge. Now, certain people who come in the zone of consideration when there are some group D posts available by your seniority.
Yes.
Now, you have to show that you are senior enough.
Yes.
That you're in the zone of consideration and that there exist vacant posts against which you can acquire and where you have not been considered.
Lordship,
where is that?
Lordship, now by past part I'm not saying this the list of regular casual worker they have not even approved. They have even
no. Not a question of approval. Now you're asking for a group D post, correct?
Group D post if there is a vacancy. But
if there's no vacancy, how can you?
Lordship, my prayer here is they have not conferred as a regular casual as per the provision.
Your list is here.
This is only the list.
Then what?
But they have not given any benefit.
I don't want to argue with you. The thing is that now, what benefit?
As per this section 5 is there, my lord, where they're supposed to give the for lordship, we're supposed to give all the benefit to the regular casual worker. This is only a list. They are provided.
What benefit are given? Show.
This for page 23.
They are not giving you leave.
No, nothing.
Why not giving you leave?
No, this benefit.
What benefit?
This RCW is entitled for to earn leave on first year basis at the
where have you applied for earn leave and they've been denied?
Once I am appointed as
where is that? Don't argue in the air. You're a lawyer, remember.
Lordship.
You're not talking in a tea shop outside to someone. Yes.
No, my argument is they allege that they have forwarded my name for conferring as a regular casual worker. Once I am confirmed, then I should get the benefit of all those as per the provision.
Where is in your name when your name already appears in RCW list?
Yes, that's why I'm saying that they have only appeared but not getting any benefit.
I don't think you're aware of your case also. Sorry. You're asking registration in the group D post or you're asking for you already conferred the status of RCW?
Prayer is, my prayer is to confirm me as a regular casual worker and if there is vacant post also promoted to
you're already a regular casual worker.
Therefore, they have given this list.
See, you do one thing.
Now you
withdraw the application now. You study the scheme and then you put it against the case of petitioner. How does from RCW one get appointed group D post? There are many cases of this court also, where the people have come when they are group D post vacant. They are number 1 and number 2 in seniority list. They are being considered. Then at that stage, the court can say, okay, fine. Let us consider whether they can be accommodated by promotion against the group D post.
Yes.
Now you're in the air. You're saying you're not giving earned leave.
No,
not being given earned leave.
They have not confirmed me.
Yes,
confirmed me the.
Heard Mr. P.T. Sangma, learned counsel for the petitioner. Issue notice. Anything to say, Mr. Shulai?
Lordship, yes. First, Your Lordship, he has to be conferred, Your Lordship.
Yes, that is what I'm saying. But that is
status of RCW.
It's already conferred.
No, that is only the list, Your Lordship. That is
only the list. They have not confirmed me as a regular casual worker.
No way have you shown that you have been conferred.
This is only a list, Lordship. Even they have forwarded this list.
We'll give you one thing. They will just take instruction whether you are RCW or not. Next date, if you are RCW,
yes,
will be dismissed.
Lordship. If it is RCW, let them give them.
No, it will be dismissed.
Lordship.
Yes. Yes, issue notice. Stop Ms. Andy Shulai and AG with AR Khan is present, so no further notice required. Stop the petitioner's case is that he is yet to be conferred regular casual worker status in spite of serving for 33 years as a casual worker in the PhD department. Stop. Though a list, he submitted a list of RCWs of Tura subdivision 2017 has been enclosed with petition wherein a petitioner's name appears at serial number 87. He is still to get the benefits of a regular casual worker.
Lordship.
Mr. Andy Shulai to obtain immediate instructions as to whether the petitioner is is a casual worker still, or has been conferred the status of
RCW
before the next date? This
Apply.
after 2 weeks. Yes.
Much blessed,
You
Lordship.
understand?
Yeah, Lordship, I understand, Lordship.
Yes.
Daily list
Much
item
blessed,
number
Lordship.
2. Item number 2, daily list.
Yes.
They file the affidavit.
I was directed to file an affidavit on behalf of NPCI, which we've already filed. There's some development as far as the
My
state
lord,
is concerned.
we have received information from NPCI, my lord, through our email, and thereafter, my lord, necessary steps was taken, and we have we got the details of the bank account number from NPCI, as well as IFSC code, my lord, and thereafter, my lord, details was shot from the Postmaster General, my lord, and thereafter, my lord, we have got all the names of the person in whose account the money has gone and his address, and thereafter in whose account the money was withdrawn thereafter again, my lord. So, my lord, these details, my lord, we'll put it by a report.
Status report. That's one number 6. That is this one is
NPCI.
NPC.
And we have
National Payments Corporation of India.
National Payments Corporation.
Corporation of India.
Yes.
we have taken steps to send notice to the person
Filed
concerned.
affidavit. So stop. Mr. Ensign, Government Advocate has submitted that certain developments taken place wherein the accounts to which the money was transferred and also the names of the person withdrawn the same has since been received. He prays not to bring on board to file a status report before the next date. Yes, just after 2 weeks.
All right.
Item number 3.
Who's the previous HDFC?
Mr. Sam
Marpan.
Sam Marpan.
Yes. None appears on behalf of the respondent, that bank. Respondent.
But let these matters come up after the orders, because it will take
Yes, all this. Which item to which up to which item is it?
This may not item up to 3 to 38.
Okay, next matter.
39.
Your Worship, in item 36, Your Worship, I was informed on behalf of S. Walong, Your Worship, he is our station, Your Worship, so he instructed me to take adjournment, Your Worship.
Okay, we'll adjourn only his matter and we'll cover, after we pass judgment, we'll cover his case also.
Okay.
Where's Mr. Mazumdar?
39.
You're for the petitioner?
Yes, Lordship.
Where's the respondent number 7?
Not sure, Lordship. They haven't filed the affidavit, Your Lordship. For respondent number 7.
Though time was granted to Mr. M.K. Mazumdar for filing of affidavit on 17/10/2025. There's no appearance on behalf of the said respondent today. In the interest of justice, however, just after 2 weeks. Yes.
Obliged, Lordship.
40.
Yes.
My Lord, contempt petition has been filed against the order dated 25/9/2024, my Lord.
Yes.
Relating to the benefit of MSCB for cipher categories.
What about affidavit is ready?
May it please, Your Lordship. Your Lordship, I pray for some time to file an affidavit.
How many times you prayed? This is the
Third time.
Third time, my Lord.
third time.
Last chance.
Your Lordship, we have not received instructions.
Further 2 weeks time granted to the respondents. Well, affidavit expected next date. The affidavit should be on board.
Highly obliged.
Record the name. Vice also.
41.
Yes, Lordship, inadvertently, my Lord, on the last occasion, we have not able to serve the copy to the, have not taken the initiative for step
taking
to.
any steps?
Yes, Lordship, we are praying, Lordship, because it's just due to mistake.
Mr. Sri Sama submits that due to inadvertence, steps were not taken.
Yes.
It is allowed 3 days
Take a
time
press
to
day.
take steps. Yes.
Lordship, most blessed Lordship.
Yes, after 2 weeks.
42.
Lordship.
My Lord, a clarification was to be filed, my Lord, in terms of the last order.
Where's
Supplementary.
the Debnat?
Lordship, Dr. Mozika will be pursuing the matter, Lordship.
Not Mr. any longer.
No, Lordship. Lordship, I'm praying for some more time, Lordship. We'll take instructions from the department.
Why Mr. Devnath is not in the case any longer?
No, Lordship.
We'll record the submission.
Lordship.
Yes, MS Emerchang today submits that they will be, together with the DSGI, be appearing henceforth on behalf of the respondent number 1. Prays for some accommodation stuff. Prays all this after 2 weeks. What about number 2?
We have no role, Your Lordship.
What about number 3? Who speaks?
SBI note.
It is after 2 weeks. Lordship.
The supplementary affidavit they were supposed to file as per Your Lordship's direction passed
Let
on
them do it after 2 weeks.
My Lord. Deeply.
43.
How soon will it be released? Now you've got that. You've got those.
Yes, yes, my lord.
How much is the amount, Mr. Sheikh?
Gratuity, Lordship, in one order 3,94,000, then 8,80,000, subject to deduction of 1,90,000.
12 or 13.
More or less 12.
When can you give them?
With 6 months, we'll pay in 3 installments.
Yes, Mr. SD. Because now you've got the money, correct?
Money from the state?
From state government?
No, my lord, they are paying the salary. They are supposed to pay the salary of the
These
staff.
are not the retired people.
He's retired.
These are retired.
Well, 6 months, Lordship, I don't think that they will have any problem.
Submits at the bar that the terminal benefits, that granting other terminal benefits of the petitioner will be released within a period of 6 months.
6 months in 3 installments.
My lord, installment make it 2, Lordship.
Even if I give in one installment also every month.
Lordship.
Yes, in 3 installments.
Lordship,
The same is not objected to by Mr. S.A. Sheikh, the concept petitioner. Stop. On these submissions, the matters accordingly close and dispose of it.
Hello.
To await contempt application.
44.
Please, Lordship. So I'm praying for a week's time to file my affidavit. I've received the Constitution, Lordship. I'm just awaiting because of some.
We'll call it President.
Lordship, because of.
Where is he? You call him.
Lordship, we have received the Constitution. Because we have.
They are a body that is functioning without any proper charter.
No, nothing like that, Lordship. We have a proper Constitution. I'm just praying for.
You've taken much time with this.
3 days time, Lordship. Because of my own difficulty, I could not prepare the affidavit. Otherwise, I filed my main affidavit. This was only on.
Main affidavit is bald affidavit.
Lordship, because we have not have any role to play in this case.
Then why did they cancel?
Because the district council is not filing the
at your
affidavit.
behest?
Lordship. Not my behest. Not at my behest, Lordship. It was not at my behest. I was never informed also about this. All I did was lodge an FIR.
But their affidavit seems to be a kind where they're really interested in what we are doing.
We had lodged an FIR, Lordship.
There's some motivation behind whatever they're doing.
In fact, we were never called to.
Somebody find a gun from his shoulder.
Lordship, the district council has to come with an affidavit as to how they have come with the decision.
No, the council is fine, but is anyone firing a gun from your shoulder?
Lordship, no, Lordship.
What got to you to go and file a FIR?
Lordship, what had happened is
do a public inquiry.
The petitioner, Lordship, he was running a check gate in the highway.
No, you want to see what's the mandate of your organization.
Lordship, I'll produce the Constitution, Lordship.
Many NGOs are floating around now. They become like a little government unto themselves also.
Lordship,
enforcement agencies.
In this case, there's nothing like that. We had, Lordship, availed of our legally. We had pursued an FIR and a legal notice. That is all, Lordship.
Your clients also. That
we have never gotten
seriously into the matter.
Lordship, yes, absolutely, Lordship. Which is why we had produced whatever we had.
What is the organization called?
Hindu Integrated Territorial Organization, HITO.
Territorial meaning?
With regard to the Lordship, the Hindu territory, the Khasi Jantiya, it is just a welfare NGO, Lordship. It is not involved in any such breaking of heads, Lordship.
No, who said breaking of heads? Why you bring that term? That means you're.
Lordship, no, because certain times it comes, but they have not done anything in this case, Lordship, to influence or otherwise.
Curious, because how can a validly and agreement entered into the constitutional authority.
Absolutely.
A reason being given. That is why it's has raised.
In fact, after we had, Lordship, we had filed an FIR to the police and we had sent a legal notice to them that we are receiving complaints about some illegal collection in the check gate. Thereafter, we were never called, never.
You sent legal notice also?
We sent a legal notice to the Secretary of the District Council, Lordship.
Yes,
That we are receiving
that is the last opportunity of 1 week to file the supplementary affidavit. Yes. Yes.
District Council to say why they have cancelled it, Lordship. They are not filing the affidavit.
No, they've not cancelled it.
Yes.
File?
Obliged.
May it please, Lordship?
You want for rejoinder?
Yes, Lordship.
2 weeks time.
2 weeks time, Lordship.
Yes, so place one out for the 2 weeks time to file rejoinder.
Obliged.
After 2 weeks, yes.
46.
Lord, I pray for 2 weeks time, my lord, to file affidavit, my lord.
What's the matter about?
Land acquisition matter, Lordship.
Is it linked to any other pending matter? No.
No.
Yes. This is from Garo Hills?
Yes, Lordship.
Yes, as prayed for the 2 weeks time is allowed for affidavit by the respondents. This draft one.
47.
Yes.
May it please, your lordship. Lordship, I pray for 2 weeks time in order to file the affidavit.
4, 5 and 6?
Yes, I am for the 5 and 6.
Already filed?
No. The first time I was seeking, my lord. On last occasion, we have entered appearance, my lord. I have not received the papers yet, my lord. I will just.
4?
I am for respondent number 4.
You have filed affidavit?
2 weeks time.
Okay, 2 weeks time as stated by 2 weeks for the time as is allowed to respond to file the respective affidavits. Yes, just thereafter.
Much obliged.
48.
May please.
Yes, sir, ma'am. Respondent 4.
Where's the petitioner?
My apologies, Lordship.
For the petitioner?
I've just been engaged by the petitioner. I'll be filing my power in the course of this week.
What's the matter about?
Lordship, the matter.
The house? No.
Lordship?
What's the matter?
This is relates to closing cancellation of the mining lease, acquiring lease, Your Lordship, in view of the judgment of the NGT, Your Lordship.
Have you filed the affidavit respondent number 4?
So what is state also, Your Lordship, we are yet to file. We need some more time.
It's already been filed.
On behalf of R4, it has been filed.
Okay. And what about 1, 2, 3?
Lordship, we need some more time.
Yes, today Mr. ESD submits that he has just been engaged in behalf of the writ petition and says for some time to study the matter. Like Paramis and Ishurai London AAG also praise that be allowed.
3 weeks time,
affidavit of the affidavit of number 4 stated to be on board. Yes, after 3 weeks.
49.
49 also same, Your Lordship.
49 is also.
Yeah,
It's a linked. I'm appearing in 49 also.
50.
Hey, please, your Lordship.
Yes.
Lordship, I'm praying for some more time to file my rejoinder affidavit, Lordship. Just a week's time, Lordship.
You're paying I am. You're paying for whom?
Your Lordship, I'm praying for UGC.
You are the legal aid counsel?
Lordship, I am the legal aid counsel.
Yes, MS D Cruz. You already filed affidavits. Already
Lordship,
filed.
UGC is formal party.
I am already filed.
Yes, Lordship.
Yes, please for the 2 stand for rejoinder. Yes, yes, sir.
Highly obliged, Lordship.
51.
May it please, your lordship. Your lordship, I'm praying for a week's time, your lordship, to file our affidavit. Your lordship.
1 week's
this is
time?
Yes, your lordship. This is already the 4th time, your lordship.
The 4th time?
Your lordship, because the concerned officer is out of station, your lordship.
Okay. Out of station for 4 weeks.
Not for 4 weeks, Your Lordship. I'm asking for a week's time, Your Lordship. I'll be
after
filing
ready.
it by this week, by Friday, Your
Yes,
Lordship.
Ms. submits that after we file the report for the week itself. Just thereafter after 2 weeks for this thereafter for further orders. Yes.
Much obliged, Your Lordship.
Okay. Orders in there.
Please, Your Lordship. I'm praying for another 1 week's time, Lordship, to obtain instructions.
Interim orders there.
Yes, Your Lordship.
Yes, MS Emerchang pays bonds allowed for the 2 weeks time to obtain instructions to file affidavit. This after 2 weeks interim orders. Next line shall continue until the next day.
53.
Lordship, here awaiting instruction. This is in fact third round of litigation, Lordship. Here the husband of the petitioner died 2020, Lordship. Now everything has been processed. BSF, Lordship. Now the matter is pending.
Any instructions?
No, not yet, Your Lordship.
Pension sanctioning authority, Lordship. As per the letter
Which respondent pension sanction?
that is the respondent number 4, Lordship.
Number 4.
4. And she is suffering, Lordship. Some old related.
Must be suffering. Who won't get pension suffer naturally?
No, she is heavy, suffering from some disease, Lordship. And
Yes,
more than 5 years.
The council vice Ms. Dr. Mbuzka DSGI submits that we yet received instructions. This court notes that the deceased employee or the employee the pensioner
husband, Lordship.
Pensioner husband.
August 2020, Lordship.
The pensioner, former husband or petitioner had expired since 23/8/2020, and further that this is a third round litigation for this court for term benefits. It is expected that the respondents, especially respondent number 4, come forth with instructions for the next date. Next after.
I'll kindly make respondent 3 and 4 because from 4 to then they will send to 3.
This after 2 weeks.
I'll make it 10 days, Lordship, so that
2 weeks, a copy of the order will be given to the London DSGI for
all
communication.
All
54.
This is the SOP matter, Lordship.
Yes.
Also the SOP matter.
SOP
The petitioners are A and M. Lordship, we had moved in a separate apartment.
Lordship,
So
we have
it
it
can
on
come on Thursday.
Lordship.
Lordship.
This item 4, along with the other SOP matters.
It was on Thursday or today?
Thursday, Lordship. Yesterday was visit today. On Thursday,
Matter
Lordship.
one, so.
Lordship, only the interim order we extended.
Interim orders is to continue with further orders.
Obliged, Lordship.
Second call, item number 3.
Number 3. Yes.
One of the this is WPC 217, my lord.
Yes.
This is the first item. One of the petitioner before your lordship by annexure 1
yes
was appointed as a casual employee, my lord, by the annexure 1 office order.
Respondents all day.
My lord.
Respondents all only this council.
This council.
No private respondents.
No, my lord. Not by virtue of annexure 1, the petitioner was appointed as casual labor in a fixed pay, my lord. This was appointment is on 6 September 2000.
First time this court things matter.
My lord.
Yes.
Lord, before we go, I'll just surprise the court. Like there are three, four bunches of, because different posts are there, my lord. Some are peon, some are process server, then enforcement, constable, then Mali cum cleaner, junior engineer, and then junior architect and chain man, my lord. So we can categorize, my lord, peon, process server,
peon.
My lord, I've made a list. It will be easier.
You're on different pay scales.
Yes, different.
I mean the peon and process servers grade 4, right?
Grade 4.
No. Or they pay a considered salary.
Initially, my lord, before their regularization.
After regularization, they're given regular pay scale.
Pay scale, my lord. Regular pay scale, my lord. Initially,
all of them are here. Okay, yes. That will be helpful, yes. Yes, please continue.
So, my lord, as I've stated, we can categorize the numbers of petitioner before your lordship as a peon category, then process server, enforcement constable are the majority of them, peon are majority of them, process server around 3-4 of them are there, junior engineers 5 junior engineers, then junior architect 2 of them, Mali cum cleaner only 1, then chainman 1.
Junior architects.
Junior architect.
Then you have
junior engineer.
Yes. So you see not a food gate peon,
process server, enforcement constable, chainman, Mali cum cleaner, junior engineer.
Yeah, junior engineer got it.
And chainman.
Yes.
So, my lord, the petitioner number 1 before your lordship, she is a casual employee. She was appointed by virtue of Annexure 1, my lord. Dated 6 September 2017, my lord. Subsequently, my lord, the Executive Committee, KHADC, she was paid a fixed pay scale of 5,000 rupees when she was appointed, my lord, in 2017. Subsequently, thereafter, my lord, by Annexure 3, page 13, she was regularized, my lord. Same post. She was regularized with a pay scale, my lord.
That is page 13.
Page 13, 3rd January 2025. After serving for almost 7.5 years, plus maybe now will be 8 years more, my lord. And she's been drawing the regular pay scale. Thereafter, my lord, if your lordship come to the last page, Annexure 5, page 18.
No, I don't understand this order,
my lord.
Now, the thing that you just come to this order 13. In this council, the executive committee is to regularize the following name casual to the post indicated hereunder. They regularize, right? Then and after that, after the names, the post is purely temporary, transferable, and terminable. Meaning,
my lord, that's the nomenclature which this council.
After you regularize, then you give a rider that is purely anytime.
Temporary. So, my lord,
well, generally, all government
is a template which they are using.
Regularization will not come terminable. Yeah. Only if you're temporary.
Any appointment is this clause is always there.
No. Only for temporary appointment. Yes.
This is a template which is being used by, we can say, my lord.
Okay.
My lord, the petitioner has names is reflected at serial number 2, my lord.
Yes.
These are the posts which has been regularized, my lord. My lord, by virtue of order dated 30th May 2025, if I may read, my lord, consequent upon the decision of the Executive Committee, KHADC, dated 27 May, page 18, my lord, Annexure 5, dated 27 May 2025, the regularization of Srimati Korla Idor Kriamujai as peon by office order number so and so dated January 2025 is hereby revoked. As the same has been done, the host of the applicable rules, this order will take effect from 1st January 2025. However, 1st June. Yes. However, the casual appointment of the incumbent by order number so and so dated shall continue. So, my lord, after my regularization, I was reverted back to as a casual employee, my lord. My lord, the grounds, or the reason of my reversal, which has been given by the KHADC, is that my appointment is the host of the rules, applicable rules, my lord. They have not specified under which rules or under which provision of the rules my reversal has been made, my lord. That's the first aspect, my lord. The second aspect, my lord, I was never given any show cause.
Yes.
In spite of the fact that during the period when I have joined my duty, my lord, there was no complaint whatsoever. Performance discharging my duties diligently to the satisfaction of all concerned. No reason whatsoever has been given, my lord.
Only that is legal appointment. That's what they say.
My lord.
Yeah.
So no show cause has been given. No opportunity to be heard has been given, my lord.
Yeah.
So that's why we are before this honorable court, my lord. Without, my lord, even if what the respondent is saying that the host of the rules, my lord, the rules provide that not show cause have to be given.
Where the rules?
Rules, my lord. We have given the copy, my lord, on the earlier occasion. The 61, rules of 1961.
This is a Khasi Hill Thomas District.
My lord.
Council Service 161.
My lord.
Which, now come to the rules. Yes.
My lord, well, if your lordship kindly come to rule 4, my lord.
Yes. Date of birth.
No, my lord, will kindly. Your lordship will find at. Chapter 3, my lord.
Page 24. Page 24.
Page 24.
Page 25.
24.
24, sorry. Not been amended these rules, Mr. Dingdo.
No.
It's not tallying. The one which I'm having is not tallying with the one which has been given to the court.
Appointing authority in all these cases, executive committee.
Executive committee.
Executive.
Yeah.
My lord, this is a general rules regulating appointment and promotions, my lord.
So, rule, this is rule 100 and how is the rule?
Chapter 3.
Chapter 3.
Rule 1.
Chapter 3.
Rule.
Page 24, my lord.
Rule 1. It starts from Rule 1. Chapter 3.
Page 24. Page 24, my lord.
Yes, yes. The strength of various cadres in
Yes,
of different
yes.
classes, services,
Yes.
and the nature of the post therein shall be determined by the committee.
Your lordship.
Right, the appointing authority may leave unfilled or hold in abeyance any vacant post without thereby entitling any person to compensation. The committee will also create additional permanent, temporary, or special posts in any services. Yes. And 3, this is the recruitment of all classes of service. That means all across the board, top to bottom.
Yes,
yes. Will meet after assessment but come to examination or basis or examination. So now your case is that you didn't go selection process.
No, my lord. I was appointed as a casual. Thereafter, I was regularized by the executive committee, my lord.
There was what exercise? No exercise was
No
conducted.
exercise, my lord. No exercise has been conducted because this is the regular procedure which
Regarding
is.
your suitability, nothing was done.
No, my lord. This is the regular procedure which is followed by the discouncil, my lord. We had
Regular
filed.
procedure.
This is the procedure which is followed by the
rules
discouncil.
say that recruitment should be by
Rules is- my
regular
lord.
procedure over and above the rules.
My lord. But this is the general practice which is followed by the discouncil, my lord. We have filed an RTI to that effect also, my lord. So out of the entire, right from 1971, if my lord see the rejoinder which I filed an RTI to that effect right from 1961, my lord. Only 2 advertisement has been made so far, entire right till date. That is only for the post of the magistrate. My lord will find the RTI which have been Your Lordship will kindly take my rejoinder at page 13, annexure 1.
1 second.
My rejoinder to the affidavit filed by the respondent.
Indicate for board, yes. But I should know. Yes, sir.
Page 13, annexure 1. Malad, this is the
detail.
This is rejoinder dated 28th August 2025.
Yes.
Rejoinder of affidavit to the affidavit of the opposite party filed by respondent 1.
Page 14.
Page 13, annexure 1.
Annexure A.
Annexure A. This is the RTI which was sought after the filing of this writ petition. We have sought this the entire information from the KHADC. So, number 1, entire list of employed by the KHADC, Shillong, present along with their posts, the mode of recruitment and selection process in the appointment of the employee to all the posts in KHADC from 1972 till 2024. Number 3, list of employee appointed to all the posts in KHADC, Shillong from 1972 till 2024 and their mode of appointment. Advertisement of all vacant posts in the KHADC which are subsequently recruited by virtue of the said advertisement from 1972, 90 and 2024. That reply to this application, the reply was given on 29 July 2025, right? Annexure B.
Yes. Where does it say there? All appointed just like that?
My Lord, if Your Lordship see, this is they have. If Your Lordship come to the next page, page 15, information under the RTI sought for by so and so. Enclosure at annexure 1. This is the list of employees. All recruitment and selection process in appointment of the posts KHADC governed by KHADC. All recruitment and selection process in appointment of all the posts in the KHADC is governed by KHADC. That's number 2, information. Information number 3, enclosed as annexure 2. Well, this annexure 2 is page at annexure 2 is page 29, list of the employees. This is annexure 2. Then information number 4, available record relating to advertisement issued by KHADC enclosed at annexure 3. That, my Lord, will find at page, starts from page 53, my Lord. These are the, my Lord, the advertisement, my Lord.
53.
Page 53, my Lord. Onwards. It starts from there, my Lord. So this, in this particular, in this.
What's by promotion?
This is by promotion, my Lord. Then Your Lordship will come. This is one aspect of it. This is the one. This is 54. Then starts, my Lord, the 55 onwards is the advertisement.
Where are the advertisements for these posts, these ministerial posts?
No, my Lord. These are the only
advertisement it shows.
No, my Lord. These are the
advertisement. One also advertisement.
No, my Lord.
For these process servers and force
nothing, my Lord. Nothing, my Lord. No other posts, my Lord. These are the only posts. Your Lordship will see from page 55. This is with regard to the 3 vacancies.
Totally different. This is it's not an executive site, so we will look at that also.
We have,
and even other one also is for undersecretary. Undersecretary is a promotion. What?
These are the only advertisement which they have furnished to us, my Lord. These are the entire
only with regard to magistrates advertisement.
No other advertisement.
Apart from yes, that's the admitted fact.
Yeah.
So, my Lord, as on today, whatever regularization has been done in KHADC has been done in this manner only, my Lord. My senior also will admit to that.
So how
no advertisement has been floated, my Lord. All the posts.
What is the now? How many people have been appointed like this for 77 now?
Almost everyone, my Lord.
As my friend had pointed out, almost everyone. Now,
when the exact number, can you furnish the number?
Exact number, my Lord, will see at page the number of employees in the council.
547. 727.
And how many retired employees are there who are availing of pension?
My lord, we have stated here, I cannot say exactly how many.
But is it run to 1,000? No.
Must be, my lord, because here we have given 727 total employees as of
Now, who's serving?
Yes.
And okay, and the pensioners? No
Because
idea.
pensioners also here at this council, my lord, it's only 5 years they get pension.
Okay.
It's only for a period of 5 years. Now, my lord, the only difference, I would say, between the petitioners here and the other appointees is that the posts where they have been appointed to are non-sanctioned posts.
So how can it be regularized?
Yes, that's exactly the point. Firstly,
So you mean to say that
they were
there was no
regularized
post
in
that
a
just-
non-sanctioned post.
Non-sanctioned, there's no post.
There's no post.
You can't be regularized against a post that
Yes,
doesn't exist.
Yes.
So that means you appointed against posts that do not exist also.
Yes. The admitted
Casually, yes, of course.
Yes. The admitted fact in all these cases, my lord, is that firstly, the posts are non-sanctioned. And secondly, there were no advertisement. My friend has correctly pointed out that in prior occasions, all the appointments were made de-horse rule.
Rule of thumb.
Yes. So that's
okay.
That's why when
Fine,
the,
okay.
when this
if you
exact
access the court, how do you propose to settle this matter?
That's why, my lord, we have not terminated them completely. In some of the cases, we said you'll continue as a casual employee. Now it's up to the executive committee to take a call. Lordship is well aware of the Uma Devi case, where a one-time.
Yes, one time, yes, but then
scheme.
like even the state government also,
Yes.
they have taken a call as to how to deal with it.
To deal with these.
So are you contemplating any? It'll have political implications.
Exactly. Because all this has been done
Yes.
50, 60 years, my lord, this has been going on. And the new
61 to 61.
And the new executive committee thought that everything should be. Now we have appointed a recruitment committee from outsiders.
That has been done only in June of this year, my lord. So
No,
We are trying to do it.
It clear the act. It's
Yes.
a constitutional authority. You can't have.
We have to clear the mess. My lord. That
the
is
entire emergency councils, all the three, not so much is because of
Yes.
these 2,000 employees in Giant Hills.
Now, the financial implication, my lord, is even for these petitioners, every month now we have to pay around 12 to 13 lakhs.
More than that.
Yes, they're having surplus budget, my lord.
No, having a surplus budget is not the.
But the only thing is that this is a total discrimination.
How do you balance the not discrimination? The thing is that also you have to be clear what rights are vested in you. If you arise against non-sanctioned post.
Because you cannot say that just because it's been done earlier.
Ten wrongs won't make.
Two
wrongs won't make a right.
True, my lord. But the only thing is that right, my lord, some semblance of right has been put upon me by virtue of the fact that I've been.
So then you'll
I've
be
been given a pay
casual.
scale.
Have been restored back to the regular scale now?
Yes, my lord. After the stay order, they have been giving me a regular payment.
How many petitioners altogether here for the court?
Altogether, my lord, there are 30 altogether. 36 of them. One is
And
only.
how many others are similarly situated?
No, the others, my lord, who have not come to court, all are serving in a sanctioned post. That is the only difference.
They've been regularizing of sanctioned posts.
Sanctioned posts. Why? The question from the court will be why? Why did you pick these persons? Why not the others? Now my answer
That
would
is
be
why. That's
yes.
why only if 727 people are serving who are appointed without any due process, then why only 38 people have come? That is the next question.
Yes, the next question. That is my answer also, my lord, because they are serving in non-sanctioned posts.
These are
And now-
7 non-sanctioned posts.
Yes. Now there are cases also, my lord, 2 or 3 of the petitioners were appointed on the same day and also terminated on the same day by the previous executive committee. So
How
these
is that possible?
Yes, these sort of things are happening.
Same day appointed, same day terminated.
Yes.
Two of them.
And then there are other
They're
cases.
here before the court.
Yes.
One is Mr.
But
Singh.
by which?
Mr. Singh is appearing in one case. That
Who's
is-
appearing? Which
Item 34 and 35. ma'am.
WPC number?
269, my lord, will come to serial number 33 and 34 and 35.
269.
269.
Yes.
And
Your lordship will see Patricia Lingdor enforcement constable. Initial appointment was on 25/8. Regularization was on 24/1, and on 24/1 itself that also was recalled.
This after the new executive came to power.
No, that is before. Before. The day before the Model Code of Conduct. Around 17 people were appointed in the morning and terminated in the evening.
This is a very unique case, I think.
Because the executive committee now has to start somewhere. We cannot allow that this type of appointments should continue.
And the number 263, Larinia Pungro.
26126. Larinia Pungro.
Appointed against a regular scale. 260-2025.
Yes, there are some who have been appointed directly.
Directly.
Without having
Directly,
any.
not
Yes.
even casual. No?
Not even a casual. Some of them have been appointed regular.
And then discontinued from service.
Yes.
24.
Yes.
You came, this matters were filed when last year.
This was filed this year only.
So she's still in service now?
Yes, by virtue of these.
But how can she be in service if it's 24 is discontinued from service? It's very strange. See, because 21/1/25. Upper Mali.
29 May 2025.
Or 25.
25.
Okay. I was wondering how can
Not last year.
Okay.
With effect of 1st June 2025.
Let's see affidavit.
The other aspect, my lord, as far as the sanction post is concerned, my lord, how would we ascertain now without any advertisement which has been made so far, no advertisement has been made, how would anyone know that whether the post which has
Firstly, Mr. Dingdo, you have to furnish a list of how many sanction posts are in.
We have, my lord. In fact, we were asked by the court to furnish a.
You have to fetch an affidavit, I think.
By way of affidavit, we have done that.
Is there in record
Yes,
affidavit?
Yes.
Where is that?
Take it over. And we filed a.
No, affidavit has not been filed.
The list of the we want to get an overview of how many. You see, if you want to rationalize everything, at least the court has to know how many posts are there.
Yes.
How many people serving there? How many posts which are sanctioned, which are not sanctioned? How many sanctioned posts are there? What's the strength in every cadre?
No, they have not filed as such, my lord.
Yes.
That's what very important because, my lord, then only we'll be able to ascertain whether this.
So when you rationalize it, then we rationalize against sanctioned posts and whether how much casually you can accommodate also.
And in fact, my lord, we'll find in the rejoinder, which it's a reply which we have given, my lord, page. What you will see at page 29 onwards.
Of the rejoinder?
Of the rejoinder filed by the petitioners. Because they had sought for RTI.
Where's the sanction post? 29.
29 onwards. No?
What's your cadre strength now in all different cadres? That you have to undertake exercise before the next date. What is your sanction strength of how many sanction posts are there? How many cadres are there? How many people are been at the different cadres, strength of each cadre, and how many people are in the casual, employment? Then we'll see 727 working whether casual workers outnumber the sanction posts.
Well, we have filed an additional affidavit also as per the direction of this court. On 17/9/2025. This is on
Well, this is the first time I'm touching this matter.
An additional affidavit filed by respondent number 1 in compliance with the order dated 9/9/2000.
Yes, what do you see here? Those are part of the recruitment committee.
Yes. No, page 6, my lord. Because we have specifically been asked for the post of peon.
Page 6.
Page 6, annexure 1, my lord. So it would appear that there are 48 posts of not 48 posts, my lord. There are 48 people have been appointed as peons in the establishment, my lord. And out of these,
1, 2, 3,
number 36, 37, 38, 39
6, 7, 8, 9.
were before this court, my lord.
10 are not.
Yes.
You need appeal before this court.
Yes.
I want an entire list from the District Council. Your entire roll of employees, different cadres, how many people are serving each cadre, how many sanctioned posts in each cadre. That's all. And to match with the 727 that you're saying. Then we'll, how do you rationalize it?
It doesn't match also even now, madam. They, as per the list, is 7.
They will know how many sanctioned posts they have. In the course of hearing, it appears that there's a requirement for the preparation of a list,
comprehensive list,
comprehensive by the District Council respondents as to the number of sanctioned posts available and the strength of cadre in each. The strength and the strength of a cadre in each section. And the number of employees in each cadre, sorry. Number of employees in each cadre have been appointed against sanctioned post staff. Further requirement is for the submission of a list concerning entire all employees of the council, especially the number of casual employees who have been appointed who are serving in different cadres. Is that possible? Let me exercise, but it should be done.
It can be done also, my lord, because I was looking at the budget. Now, if you see the budget,
yes, it's there.
It is very clear. Yes, the cadre.
It's that you know, praise without 2 weeks' time to prepare this.
A week's time, my lord.
1 week's time. This matter up to 1 week. Yes. Then we will try to give you a roadmap. I don't think it can come from the executive themselves. This decision will be very. Yes.
Well, this interim order there till today.
Interim orders to continue for the orders. Yes.
Obliged.
Make it simpler.
Hearing 55.
Yes.
Malata, in this matter, the government has already filed affidavit.
Yeah.
By saying that the managing committee has no other sources.
The same matter?
Yes, Malata.
So what do we do then?
Malata, my humble submission before your lordship.
So that order they are contempt.
Malata.
That means where will they take out the money from then?
Yes,
They have already submitted and it makes it very clear that we don't have any source of income. Other
Yes.
source of income.
My humble submission before your lordship, since this honorable court, the learned single judge as well as the division bench has clarified one thing, that the petitioner is entitled for at least the basic salary. When we go through the others judgment of the learned apex court, wherein also the manner of appointment and selection doesn't matter.
Yes.
At least basic pay they are entitled for. Kindly come to the last observation of the division bench of this honorable court, page 55. Sorry, page 68. Page 68, last portion from the below 1, 2, 3, 4, 5, 6, 7, 8 lines. In that view of the matter.
Yes.
in that view of the matter, the state government is under duty to enforce Article 21A of the Constitution and provide the minimum of basic salary of the government science teacher to the respondents, which appears to have been rightly worked out and calculated by learned single judge at rupees 14,100 per month. Besides, the state government would also be within its right to enforce Article 21A in the manner as it thinks fit by bringing appropriate legislation. It doesn't appear that after coming into force the Article 21A, the state government has enacted...
See, the thing is that, again, we come back to the same square one.
Yes.
That they will, now they have no source of income, right? And then what is happening? They're recovering from teachers.
Yes.
They're recovering from, to pay you, they have to recover from the managing committee.
Managing committee.
So how will, Mr. Shulai?
Lordship.
That is the observation.
Lordship, that power of deduction, your Lordship, is given by the...
Not deduction. The things that the court said that you pay them. And
You
then
pay them and after then...
reduce
Yes.
the grant in aid to them.
Yes, your Lordship.
So you do that.
Yes.
We are doing that, your Lordship. That is what we have done, your Lordship.
They have paid, but that was deducted from the salary of the petitioner. That's the problem. That's why you are before this Lordship. They have already released.
They're paying other people. They're paying, who are they paying? They're paying the... confusing now, forgotten. One second.
This deduction, your Lordship, is only for the period of 2007 to 2016.
Yes, that amount has already been relieved. The arrear amount released to the petitioner subsequently deducted. So, giving that amount bearing no meaning at all.
See, grant and aid, because see, the thing is, direction is to recover from managing committee, not to recover from them.
Yes, direction from the...
We are not recovering from them, your Lordship. We are recovering from the managing committee, your Lordship.
Who's deducting from them?
Lordship.
Kindly see the impugn orders.
My lord. Granting it, which we are receiving.
Well, kindly see the impugn orders, which was passed by the district school education officer, wherein clarified the deduction has been made from the salary of the petitioner, but pays 85. That is the 85. The first petition number 1, well, got it?
1 second.
Page 85.
Yes.
But this is the typed copy. Renewal of fund for maintaining the recurring grant in aid to science teacher in existing ad hoc aided permitted secondary school during 2022-23. Well, name mentioned, William Nagar School, Secondary School, Akhtaruzam. This is the petition number 1. Amount per month, rupees 13,000. That is the salary. Period 1/7/2022 to 31/8/2022. They have released. And total amount 62,000. Amount deducted, less amount to be paid by the MC 20,600, and thereafter they release 41,400.
Yes.
Like that, directly deducted, and this order issued by the district school education officer.
Yes.
Not from the directly the money sanctioned to the managing committee.
But if this is the only money sanctioning to them, that's their case. There's no other source
Yes.
that they're recovering
Yes.
from there, because this is the part of grant in aid. The division bench order says recover from grant in aid. So what to do?
But that's in that case, well, this is a welfare state, well.
Welfare state, yes.
State has the so, Malad, if we go through the single bench judgment, Malad, they clearly clarified that it is the wisdom to the state government. In single bench order, Malad, this is clarified.
You cannot go back to...
But in the division bench, Malad, over and above, the last observation, Malad, said like that. As such, this writ appeal is dismissed with modification of the impugn order to the effect that the state government can recover the amount if spent in paying the minimum of basic salary to the science teacher over and above the grant and aid being paid to such institutions.
But it's already over now, the recovery. Recovery is still going on.
Yes, no, my lord. After the stay order of this honorable court, my lord, in the meantime already out of 3,59,000, near about 2 lakhs has already been deducted. Has already been deducted. Change the sum amount in the name of the sanction of the science teacher, my lord. The government has already released. So in that case, my humble submission is being the welfare state. The state
so we
can do something.
stop for the recovery, or we direct for refund of the recovered amount.
Yes.
Also. Mr. Shulai, you have to show the way out. It's not a legal problem.
Lordship, because that power is there, your lord. If lordship kindly have P69 of the writ petition.
No, this last part, as such, a rebate dismiss modification implement order, the government can recover the amount is spent. That's a part, right?
Lordship, if lordship, on top of it, there is a sentence thus.
Yes.
Thus, the state government would be at liberty to protect the interests of teachers and impress upon the private granting agency to bear the financial burden of making payment of the minimum of basic salary to the science teacher, which is being paid to the science teacher working in the government. As the state government is already extending granting aid to such institution, for the rest of the amount, it can direct the institution to pay directly, or after making such payment, it can deduct from the amount of granting aid paid to the institution. That is there, your lordship.
No, can you, what do you call it? It can. Doesn't mean that it shall.
Yes. Yes,
lordship, because we keep them.
No, that is different. Now the situation is this: is it pay them that basic salary at least, that 3,100 extra, and that amount shall be the burden of the managing committee, which we can recover from other resources of the managing committee, right? Suppose they have other funds coming, you're supposed to extract it from them by decreasing the amount which you've already you adjust the amount. Now, what managing committee is saying, they don't have any resources. The only money that's coming the only money that's coming is the salary of teachers. Yes. And now what you have done is that in implementing the order, you have deducted from teachers themselves.
It is not that they don't have the, if lordship, we have filed an additional affidavit. We have filed an additional affidavit, your lordship, in one of the school.
Yes. They always categorically said that they have no other sources.
No, your lordship.
Then, what are you going to do? Sell the property?
No, if lordship, I kindly have the additional affidavit filed by us, your lordship, at page 8.
Not getting anywhere. Page 8.
Lordship, yes. They have the income, your lordship.
Where's the income?
Lordship, can you see at clause 4? Admission and session fee, your lordship, per hand. It comes
that
to
one is 4,90,000.
Yes.
120 goes chowkidar, 90,000 for a clerk, and 1,90,000 is contingent, and so.
Total balance is rupees 8,000, 6,000.
So they have 6,000 in the pocket at the end of the year.
Most of the schools have shown zero balance, telling by their affidavit.
Total income 39,22,000. Total 39,18,000.
Yes.
Page 14, my lord. Balance zero.
So, Mr. Shulai, what do we do? Then we just hands off. That the order of division bench is there. We can't interfere with it.
Yes.
Then we can't interfere with it.
Yes.
What to do? Then they are at liberty to
But
take from the
only in that your lordship has rightly pointed out that not shall can. So in that
only in that place they can move.
Yes, my lord. In that case, otherwise, my lord, I can also not giving any force because the division bench's order is there. But only what can and shall. In that case, since a welfare state, my lord.
Yes, but Shulai, what to do? It's all in your hands.
Lordship, a solution has to be. Lordship, let it come on some other day, Lordship. I'll have a. I'll try to find out what is the solution, your Lordship.
Do you need a direction of the court?
Lordship, let me have a talk with the officer, your Lordship.
Yes.
In the course of hearing, on the point of the recovery of the amounts as directed by the division bench of this court, by order dated, that order 15, order dated, that division bench order?
My lord, division bench order 4/3/2015.
4/3/2015, wherein it has been directed that
page 69, your Lordship,
the state government can recover the amount if spent in paying the minimum basic salary to science teachers over and above the grant in aid being paid to institutions. You do one thing. The numbers para also. Come no. Wherein is given that the state government can recover the said amount, rare amounts, from the managing committee, and as the managing committee has expressed that they have no other source of funds or revenue, Mr. N.D. Shulai, please be able to obtain instructions to bring a quietus to the matter.
Lordship.
Yes, list after 3 weeks. Otherwise, we can make it very short.
Yes,
we just follow the order of the division bench and cut it down.
Yes, my lord. Exactly.
Next item to your detriment.
yes.
Next item is same.
Oblige, my lord.
Yes.
61.
Much obliged.
Oblige, your Lordship.
But after 3 weeks.
Okay.
Much obliged.
Please, Your
For
Lordship.
rejoinder.
We have just received, let it be
Just now.
posted.
This morning,
Just
Your
now.
Lordship.
You file it just now.
Today, Your Lordship.
Isn't record? No. Ms. Ibla submits rejoinders file have just been filed today.
Copy
List after, list after
2 weeks, Your Lordship.
2 weeks. Okay, 2 weeks.
Lordship, interim may continue.
Okay, interim orders will continue until the next day. Yes.
Lordship. Lordship, sorry, that item number 2, Lordship, I was here. Lordship had marked P absent. Kindly consider.
Why can I consider the thing of inflicting the cost upon your client now to repay that, to do good the okay, record his name. Yeah,
Item number 2. Thank you so much. Pleasure.
Lordship.